Good morning, good evening, good afternoon, folks. No matter where in the heck in the world you are, it's the one and only V, the Gorilla Economist, coming to you live on this edition of Strategic Life with the man of the hour who needs no introduction. Of course, I'm talking about John J. Singleton. You can find him. Links are in the description box, folks. aceofcoins.com, aceofcoins.com, as well as aceofcoins.club. And you can go ahead and book a session with John, and he can show you the way, not only for asset protection, but also to help create multiple streams of income. And with that being said, John, good afternoon, buddy. How are you?
Yeah, good. Thanks, BJ. Appreciate it.
Doing great, my man. Doing great. So I know you've been working on some things for us, and you're going to be sharing some things, especially divorcing the state and a lot of the things you want to talk about. So I yield the floor to you, John. Take us to the heavens, my friend.
All right, very good. Thank you. So I did this presentation a while back, and I had some negative comments, and I think it was from women. And so I just want to preface what I'm saying is this is not about disparaging women or denying them rights or anything like that. What we're trying to do here, I'm trying to demonstrate how you can remove the state from your marital arrangement. Okay, and so maybe when you hear this, you'll think of those stories, and hopefully you weren't in this situation, but you'll think of the stories that people told you about their horrific experience in family court, how it was so expensive and the guy lost everything. And so the way I explain this is with a stereotypical example. Okay, there's some versions of this that require a little bit explaining, but this is where we're dealing with family court and a situation where the wife wants to start a divorce, and so she leaves the household. Okay, and she leaves the household without terms. Now, keep in mind, she's in the household and she's getting all the benefits of the household. You know, she's enjoying the use of the money, the comforts and protection of the household, and the enjoyment that's related to that, and all the, you know, all the things that go in there. But she leaves the household and she wants to separate. She wants to divorce the husband. And so she goes to a divorce attorney, and the divorce attorney files a petition for the declaration of the dissolution of the marriage. It's easy enough because the courts have jurisdiction over several things. The courts can declare something to exist or not. The courts can enjoin something from happening. And also the courts can award damages if given the proper, you know, allegations and evidence, okay, if you prevail. So when someone files a petition for the dissolution of a marriage, he's asking the court for declaratory relief. That means to declare something to be or not to be. In this case, to declare that a marriage is dissolved on a particular date. It's important that we have this in society because for legal reasons and for financial reasons, we need to have this date stamped by the court. But what we don't, we kind of miss this, where in the stereotypical example, the wife leaves the household with no terms. She was enjoying all the benefits, and now she's not going to be able to enjoy the benefits because she has to be in the household to do that. So she leaves the household and she wants to file for divorce, as people say. So she goes to a lawyer, the lawyer writes the pleading, the complaint, goes into the court and starts demanding things. For example, money and property and custody and all these sorts of things that go with this type of proceeding. But the court can't just give her things like this because, like I said before, she was already in the household, she left without terms, and now she wants to use the court to get new terms, to impose new terms on the marital relationship, and then dissolve the marital relationship and get more terms than she had while she was there, possibly. Now, sometimes that's not the case. But what she has to allege in the pleading, and I'm not talking about a case where the wife rightfully is going to go in there and say that the husband was abusive, and maybe he was. And we're not talking about that, because where there are allegations of abuse or neglect or imminent harm, undue hardship, those things give the state a reason to get involved in the allocation of money. We all know this is alimony and child support and child custody, okay? The state cannot get involved in those matters absent allegations of abuse or neglect and absent allegations of how the abuse or neglect can be cured by changing the way money's being used in the household, reallocating cash flow money in the form of what we call alimony, okay, or child support and custody. So the first thing that, this may piss you off, you guys might be listening to this, you might get angry, and you should be. You should understand what your family court is doing. The family court is going well above and beyond what is being asked in the beginning with the pleading. And it's the fault of the lawyers, and they're allowing this to happen, and these guys know better. So you come into the court, you ask the court to simply declare the dissolution of the marriage. The judge should look at that and say, well, is everybody in his right mind? Is everybody a resident of this county? Do I have jurisdiction? It's irreconcilable differences. Maybe he wants to interview the two. Maybe he wants to send them to counseling. Maybe he wants to order mediation. But in the end, more than likely, he's going to grant the dissolution, and that's where it should end. But guess where they started? They start the whole proceeding after the petition's filed with discovery. That is collecting the information about your bank accounts, your assets, your property, all this, your money and all these things, okay? Why? Why are we discovering your assets when there's been no adjudication of a debt and no allegation of a debt? So think about this. Can I come into a court and use the court to get more rights and more claims against property or things than I had when I filed the petition? Of course not. You can't use the court for that. Our court system can only give you what you're entitled to. So the first rule or the first understanding that I show people is that the caption of the case usually reads plaintiff versus defendant or petitioner versus a respondent. Husband and wife are not adversaries. Why is it that all throughout your existence, your experience in the marriage, you're viewed as one person? I mean, even if I try to get charging order protection in a company, you can't do it with husband and wife. Why? Because they're considered one person. But how is it that there are all of a sudden two people in a divorce proceeding before there's been an adjudication or the dissolution ordered by the court? They're not. It's not supposed to be that way. But the courts can't proceed unless there's an adversary. So they fake one. They make one up. So then the court goes in and collects all this information about money and how it should be spent and who should start changing, how he's paying, who, what, and intruding upon the family. So what's happening is the petitioner is typically, if it's the wife, is typically using the court to get more benefits, as I explained. The court cannot then consider matters that are not within the pleading. So you go into there asking for a dissolution of marriage, and you then participate in this discovery of all your financial assets. But that's not, there's no allegations about a debt obligation. There's no adjudication of debt, but yet there's all this discovery. We know this as post-judgment discovery. If the bank sues you for a debt you didn't pay, the bank first has to win a judgment against you, and then it can ask about where your assets are located. Well, this is how family court begins. You file the petition, you're not alleging a debt, but yet the court's going to investigate all your assets for the purpose of splitting it up or whatever the court wants to do or whatever some statute decides should be done, which, by the way, that's not how it works. The statutes don't work that way, but this is what the judges are doing. So statutes as well do not create more rights. The court itself cannot give new rights to parties just because someone filed a petition. So it'd be like if I go in, if I sue somebody who legitimately owes me, $4,000 on something, and while the case is going, maybe I send a letter to the judge or I file a motion to the court and I say, hey, I know I'm suing for $4,000, but I really want another $2,000 because of some other matter. The court can't hear that. That will be removed from the proceeding. I can only talk about my original case. Now, if I want, I can ask permission to revise the pleading, and I can then bring in the other $2,000, and then I have to support my allegations. I have to say why I'm entitled to that. Well, how is the wife who left the household forfeiting all of her benefits, abandoning all her benefits, able to come into court and then acquire all these new benefits and things that she just gave up when she could have obtained them or in some way worked it out with the other party? I hate to say that word, but this is what's going on in family court. So you have to realize this. When you start a petition you're only asking for declaratory relief, and the court proceeds to engage in post-judgment discovery like a creditor would, like a creditor who won a case against you before the case has been even adjudicated, then the court is being used to obtain or give the one party more property rights than he had or she had before the case was filed. This is what's going on. And so we know this, and you guys are going to get a little bit angry. You should. We know this as an involuntary receivership, or it would be a similar way as if, let's say, instead of Citibank suing you, Citibank filed an involuntary bankruptcy against you, and the trustee just took all your property to liquidated you to pay all the creditors, not just one creditor, but pay everybody. That's what's going on in family court. It's being used to force you into a bankruptcy proceeding, liquidate your property, and destroy your wealth or your ability to acquire wealth. This is what's going on. So the first duty of the court is to not do that. It's supposed to preserve what was before it. It's supposed to preserve what the family was doing before then. It's not supposed to just jump into acting in the best interest of the child, acting in the best interest of the spouses. It's not supposed to do that. It's supposed to keep things the way they were. Here's the problem. In the petition that's written by attorneys, the attorneys are so incompetent, they don't even allege to the court what was before the petition was filed. We know this as what's called the status quo. This is not alleged in the complaint to ask for declaratory relief, dissolution of marriage. So the court is unable to preserve what was before because it doesn't know what was before. It was never alleged. So the court is not able to intrude upon what was before, how the children interacted with their parents, how money was spent, who paid what, when, who took Johnny to the soccer game and all these things. The court can't do that, but it's doing that. So the court then can only, here's a situation I'll describe. The situation where the court can intrude is where in the pleading, there's allegations of abuse, for example. Okay, you can have allegations of abuse, neglect, imminent harm, or undue hardship, and there's some versions of that. But where there are allegations like this, the court can intervene in the use of money and child custody and making payments and so forth, provided that changing those things would likely result in curing abuse or neglect. You see how detailed this gets, but yet the petitions are just being used as kind of like a blank check to destroy the family. Why the heck would that be going on? Well, I'm thinking about like this. I'm thinking about our system, like what I'm describing right now, the court system in family court. Why the heck does family court even exist? Your regular trial court has jurisdiction to grant declaratory relief. Why do we need family court? Because family court is being used to liquidate you. It's being used to compel you into an involuntary receivership under threat of incarceration. That's what's going on. So I'll give you a couple examples, but where the court can get involved is if there's, like I said, allegations of abuse, but then there has to be evidence of abuse. There has to be a hearing, and it has to be in the pleading. You can't just bring it up as an afterthought during the middle of the proceeding because it denies the other party the chance to respond, to deny those allegations, to object to the allegations, even to admit the allegations, but also it divests the person making them of a burden of proof. It also denies the respondent the opportunity to appeal or even have a fair hearing on these items, these statements of fact, if they're not in the pleading, okay? So here's an example. I know that I hear this all the time. So I had to sell my house, okay? So to sell your house, you have to enter into contracts. This has to be voluntarily, right? You have to enter into a listing agreement. You have to enter into a bill of sale. You have to voluntarily participate with the sale, the real estate agents or the potential buyer. You have to deal with the title insurance company. There's a lot of things that involve a contract, like for example, getting an appraisal, right? Well, these all have to be agreements entered into voluntarily. How can a court order you to do this? Now, a court can order you to do this, but you cannot be compelled to enter into an agreement that you don't want to be in, because therefore it's not an agreement. You cannot then be ordered to enter into an agreement under threat of imprisonment or public humiliation or whatever the family court wants to do, because once again, that's not an agreement, okay? So here's how we know. I'm not just making this stuff up. Ask yourself, if the judge can order you to sell your house, can he order someone to buy it? And if the person doesn't buy it, can he pick somebody to buy it? And if he doesn't buy it, can he punish that person? Of course not. Can the judge order a lender to lend money against your house so that you can get the cash out of the equity and split it with your spouse? No, because he can't require a lender to lend the money. The lender can only lend the money if it makes good business sense to do so and he wants to do it, okay? See how this whole system has been tuned into liquidating people. My theory on this is that if I'm, let's say, surreptitiously, maybe I have a whole bunch of money, right? And I'm thinking, if I'm in this town, maybe I want to eliminate the chance of competition in, let's say, the restaurant business, right? Well, there's going to be a certain percentage of people that end up in family court going through a divorce proceeding. Well, I want them liquidated. That way it prevents them from competing with me. or easily competing with me. That would be one of my theories, right? Now, there's something else that's not just a theory. What happens is your state is getting matching funds from the United States under the Social Security Act, sections 4D and E. Okay, so there's a matching funds program where the court, when it orders alimony and child support to be paid, and it does this based upon not what's in the best interest of the child, but it's doing it based upon where there's the most stable income and the largest amount of income that can be transferred, so that it can get the most money from the funds matching program. So the state then batch files all these in an accounting function to the United States and gets money from the federal government to break apart your family and marriage and be unfair to you and just destroy everything.
That is a bombshell.
Yeah.
Of information. That's a bombshell of information that, my God, this needs to be taken to the heart of the beast to end this practice, because, you know, I agree with you. I mean, if everything is financialized, why wouldn't it be? Right? Why wouldn't it be? Because and I think this is what the evidence is showing, John. It's incredible.
Yeah, that's what's happening. So, you know, in the stereotypical marriage, the wife, okay, in the divorce, the wife wants different benefits, and the pleading is insufficient. So, what do you do in that situation? Well, you know, it's pretty simple. You look at the pleading, and you see what's being conducted in the proceeding, and you go back to the pleading and say, is that supported by allegations that are relevant to discovering my property? Has there been an adjudication of debt? Is there a claim on my property? Like, for example, when the judge says you have to sell your house, and then you come in there with a copy of the quitclaim deed and you say, look, the quitclaim deed where I acquired the property, and yeah, my wife's name is on there, but it's a quitclaim deed, judge. It's public record. I have a right to rely upon this quitclaim deed. You can't change it unless you're exercising a lien interest by someone who's filed a foreclosure or claim against my property. My wife doesn't have a claim. We are married. We live there together. She doesn't have a different claim than me. She's on the quitclaim deed. So, you know, you just ignore this, you know, and when we corner the judge and we say, Judge, these matters are outside the pleading. In other words, we're saying to the judge, proceed at your own peril, because we're not only going to appeal you, and this is something you guys want to hear, we can appeal them, right? I don't even know if that's even something that can be sustained, because I think they got the whole system so corrupted. But each state has a Tort Claims Act. And here's what we do in almost every case. When the judge starts going sideways, doesn't listen to the motions and acts outside the pleading, we go into the Tort Claims Act for the state. We find the procedure for waiving the judge's immunity, and you find out how simple this is. You simply send a notice to the proper office in your executive branch, and you explain that you're waiving the judge's immunity, and you can do it for cause or not. You can I like to put for cause in there. Now you got so much time in which you can make a claim against the judge, because then he's personally liable for the damages and suffering that you incur. So that's like a rundown, because, you know, we can easier if we talk about this, but I mean, I'm presenting to you what your family court, it shouldn't even exist, but your family court is being used to liquidate you. This is why everyone's complaining, but they don't have the words for it. And I'm telling you what the words are. Now you can do something about it.
Remarkable. You know, I think somebody once told me years ago that family courts and tax courts are really not really courts. They're like what you said. They're designed to liquidate you. There's a differentiation there between them and the regular courts.
Yeah.
You know, there is. I just don't remember what it was specifically. I got to go back and look at my notes, but this was maybe 5 years ago or even more that I heard this.
There are many other examples of this, but the underpinning aspect of this that I didn't really mention yet, this may help explain even further. Lawyers are not practicing law. They're not trained to practice law. What they're doing is, and most of them don't even know this, they're practicing attornment. So I'll give you the definition. You guys can find different versions of this definition, but your lawyer is practicing attornment. If you think your lawyer's you hate him, but you're still going to hire him because you feel like if I hire another lawyer, he's just going to do the same thing. Okay.
Or he's really going to bat for me. Meanwhile, he's
not your advocate, and he's not practicing law. What he's doing is practicing attorney. And the definition is taking property from one person and giving it to another. Sometimes that means the state. And property doesn't just mean money and real estate. It also means your parental rights. your privacy. He's threatening you in public humiliation with imprisonment, and your property rights extend well beyond money. It's your right to just exist and to do what you want to do. So I just, this is like a public service announcement. Check this out, okay? And if you're in that situation, you simply look at the pleading. That means the petition that was filed, and you find in there where there's been, where are the allegations against my property? And are they supported by claims on my property? Did my wife have a different claim on my property, my house, than we had together? Does she have a claim on my furniture? Does she have a claim on my family heirlooms? Where is that claim? Is it a piece of paper, a lien instrument? No, none of that. So here's what some of these judges do. Now, what's happening is the judge is acting as a judge, but he's also he's wearing two hats. He's acting as a receiver in receivership. And just so you understand what I'm talking about here, to be sure, he's acting as the bankruptcy trustee.
Wow. Yeah.
And when you put him into a corner and you say, well, Judge, this is outside the pleading, he doesn't want to talk about that. But what he'll do is he'll appoint a receiver, some other lawyer, to then step into your shoes, into your rights that you had, and take them. That means sell your house. That means forge your signature on a quitclaim deed. I've seen him do this. So
wow.
It's the same thing. You waive that attorney's immunity. The receivers have some kind of immunity, and he now is liable for you for the damages. He's liable to you for the damages, and so forth and so on. But the very beginning is you ask for a dismissal because what is being asked for is not supported by the allegations.
Wow.
Now, what helps this, what cures it, is a postnuptial agreement. And you can do this at any time. You can even do it. I've done it in the middle of a divorce proceeding, because once you have a postnuptial agreement, you can ask the court for what's called a summary judgment before there's a trial, before the judge gets in there and says, here's the proposed decree. You've heard this before, right? Here's the parenting plan. Here's the alimony payments and all this. And if you have a postnuptial agreement, if you can ever reach that agreement, because sometimes it's impossible, you can avoid the courts intruding into your family. This is what you want to do. I did one the other day for somebody that came to me, and we can get somewhat of the postnuptial in there, but what we did instead is, because they want the date stamp from the court, I wrote the petition in the same way I'd write a postnuptial. The petition is, hey, we just want declaratory relief. We don't want splitting up a property. There's no claims on the property. There's no issues of abuse or neglect, et cetera. I put that on the petition, so the judge is pigeonholed into only doing what he's supposed to do. So very seldom do I get a case like that.
Right.
Yeah.
Very well said, John. Very well said. If people want to get some more information on this and the current project you're working on, can you give us a little bit of aceofcoins.club and what that entails?
Yeah, and aceofcoins.club, I have a video series with lots of videos on this subject, explaining, from the beginning, the understanding, and also what the procedural requirements are to make sure this doesn't happen to you, that you don't get liquidated, okay? Or to get out of it. We can even get out of it, even after the fact. We can get out of it for different reasons. But aceofcoins.club is my video series. Now, I'm adding something new, B. I didn't mention this until recently. Now, I developed this AI device, and it's now, we're going to release this probably in October. I say it's going to be fully functional in about 3 months, which means we can actually help you with the documents as this proceeds if we need to. Our objective, though, is if we get involved, is to end it quickly, okay? Because sometimes we cannot do that. So we actually have a membership program that you can have access to this device, and you have access to my team. I actually have a whole team of people, and we just sit here and work these cases. So like I just said before the call, we just like minutes before then, we just did that. It took us like 5 minutes to do that. So
that's incredible, man. That's really good news. And folks, if you want to get a hold of John, you want to start getting involved in this project, and also just contact him for the services that he offers, go ahead and reach out to him over at aceofcoins.com, aceofcoins.com. Schedule a call with him, folks. Schedule a call with him. It is absolutely top-notch, next level. John, any other things you want to add?
I'll give you one more thought here. This y'all can relate to, and I'm sorry to say that you can relate to it if you've been in the situation, or you've heard this story where the case begins, the divorce proceeding begins, and immediately the husband is ordered to pay some sort of alimony to the wife. Before the before anything really happens in the case. Okay, so what's happening is the defendant is now having to pay the other side's attorney fees. Now, somebody's going to say, but that money may not be used for the attorney. I'm going to say that money's being used to offset the attorney fees. So since when can I be required to pay my opponent's legal fees and help my opponent with my own money during a controversy? When am I required to fight against my own money? Think about that.
Right. Exactly. Very well said, John. Very well said. Folks, if you need to get a hold of John, you need to get a hold of this. I'm telling you right now, powerful, powerful information, life-changing information. Get a hold of John over at aceofcoins.com, aceofcoins.com, and aceofcoins.club. Be part of his amazing organization. With that being said, we're over and out.